Good evening and welcome to Know Your Rights. I am your host, Khadija Usher. On our show, you hear directly from attorneys who break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. Tonight, we will be discussing your rights when buying or selling land. You can watch us live on Channel 7 or on Facebook at Colorblind Multimedia Productions. You can also participate in the conversation by posting your comments or questions on our Facebook page. Joining us tonight to discuss this topic is attorney Lissette Staine. Good evening and welcome, Lissette.
Good evening and thanks for having me.
Thank you for being here. First of all, let me commend your bravery for coming on the show to talk about, of all things, lands, which was very recently a very hot topic.
It is a very hot topic.
And we want to get right into the first question, which is perhaps the first thing anybody wants to know when they're trying to procure land, is how do you determine who is the rightful owner of the land?
Okay, I think the person should take a common sense approach to it.
Okay.
So, first of all, request a copy of the title to the land and a copy of the person's identification card.
Okay.
Look at the name that's written in the title and compare it to what's in the identification card. And bear in mind that only the person whose name appears on the title could legally transfer title to that land.
Okay.
So that, except for certain limited circumstances. So, for example, if the person name appears differently from the ID that they provided to you, then you ask questions, of course.
Okay.
Perhaps the person married, you ask for a marriage certificate, and don't feel intimidated. Usually purchasing property is a huge investment for somebody.
Yes.
And so don't be intimidated. Ask questions to satisfy yourself that you're doing the right thing, that you're purchasing property from the correct person. So I said certain circumstances, the person who is naming the title would not sign, and those circumstances are where that the landowner gives power to another person to sell the land and to transfer title.
Okay. Yes.
And that is done through a power of attorney.
Okay.
The power of attorney must be in a certain form and must be registered or recorded at the lands department.
Okay.
So it's not in the form. There are certain common form power of attorneys that I see that are used in other jurisdictions. Those can't be used in Belize to transfer title to land.
Yes.
It has to be in a certain form, registered or recorded. And so the person named in the power of attorney would be able to sell land or transfer title to the land, yes. And another circumstance that I could think of is where the landowner is deceased.
Okay.
So the person who might be selling the property should have grant from the court, grant of probate, a grant of administration, so that that person is empowered or entitled, authorized to deal with the property.
Yes.
And so we would, of course, request a copy of the grant. And so what do you do when you get a copy of the title and a copy of the person's identification card?
Yes, yes.
You compare the two to look at the name,
make sure
of
they
course.
match.
Yes, that they correspond with each other. And you conduct what they call a land title investigation.
Okay.
So in a land title investigation includes checking whether or not the person obtained good title to that property.
Yes, yes.
And if in fact the person still holds title to that property, whether or not he or she has transferred it. You'll also check the description of the property. You would check to see if there's any mortgages, any restrictive covenants, cautions, if it's registered land, and so on and so forth on the property.
Okay.
On the title, sorry. You would also check whether or not the property taxes are fully paid, because you won't be able to file the transfer instrument or record the transfer instrument if the property tax isn't paid in full.
Yes, yes.
Yes. And also, it's prudent to do what they call a judgment search, which is a search of the cause book at the Supreme Court Registry.
Yes.
To see if there is any dispute in regards to the property.
To the property, okay.
To see if there's any enforcement proceedings against the property.
Yeah.
So those are things that you would look out for to make sure that the title is clean and clear.
Yeah. So you said a lot of things.
Yes, I did.
It's a lot of what I'm gathering is that apart from ensuring the first stage is to verify that the person selling it to you is the person on the title.
Yes.
There's also a bit of research and due diligence that you have to do on your part.
Correct.
Now, as I said, this is a lot of things.
It is.
Do you have to do this on your own? Or can you hire somebody to do all of these research and stuff for you?
Okay, so you could hire an attorney to do the due diligence and in fact to have courage of the transaction itself.
Okay.
You could hire an independent researcher to conduct the land title investigation aspect for you. There's also another aspect of it, which is the site inspection. That is where somebody, the buyer or somebody goes on the buyer's behalf to physically look at the property that they're purchasing.
Okay.
So you would look out for things such as, is there a tenant? Somebody living on the property?
Yes, yes.
Because you don't want to be stuck, you don't want the burden of having to try to remove that person out of the property afterwards.
Okay.
Is there someone who claims an interest in the property that's living on the property? Is there an physical easement that you can see that's running through the property? An easement is how do I explain it? A path or
a right-of-way for anything.
Right.
Yes. Roads.
Right.
Yes,
so
yes,
you
yes.
look for those things to see whether those things exist. I also encourage my clients to retain the services of a licensed surveyor.
Okay.
Because sometimes you go to the property, but how would a lay person know that the property that they're seeing is actually the property that's reflected in the title?
Yes.
You need a licensed surveyor to ensure that for you, to also ensure that the markers, the survey markers are in place, to ensure that you're not encroaching on another person's property or another person is encroaching on your property.
And I notice you keep saying licensed surveyor.
Licensed surveyor.
Like you stress that it's important.
You retain the proper professional, no?
Okay.
Yes. And so that's an aspect I think that is often, at least that I've seen, that is often overlooked, the site inspection part of it. Yes?
Yes, yes. So you've actually experienced cases where the deed is there, the physical deed, but it's not necessarily that the physical land is there, and this would be avoided by the site inspection process?
Yes, what happens most of the time is that, so the buyer and the seller takes the buyer to see a parcel of land, right? So they go there and they see this parcel of land and the buyer assumes that that's the parcel of land that he's buying. This is the title to that particular parcel of land.
Okay.
Just to find out that it's not that one, it's the one beside it or the one behind it.
Yes.
So you see, so a surveyor would assist in determining exactly what parcel of land you're purchasing, because behind every title there's a survey plan, and the surveyor would be able to read that plan and determine where the property is located.
Yes, yes. So you're getting ready to purchase the land. Should you make a formal agreement with the buyer, with the seller, sorry, and what should be included? Essential parts.
Certainly,
yes.
Certainly.
Yes.
In fact, the law requires a written agreement.
Okay.
And to be signed by the parties. No? But So as to avoid any ambiguities, or to at least try to mitigate them as much as possible, you would of course include a proper description of the property. You look at the title and you use that description that you see in the title in the agreement. You clearly identify the parties to the agreement, because you cannot sue on an agreement that you're not a party to, right?
Yes.
Yes. So you would, of course, put in the purchase price agreed upon by the parties, how it would be paid, when it would be paid, would it be paid to an escrow agent, who would be the escrow agent that it would be paid to, and so on and so forth.
Okay.
The deadlines, when closing is supposed to occur, and things of that nature, when the buyer could get possession of the property. That's important. Is it at the closing? Is it when he pays the deposit? Those are things that should be included. And if there's any special conditions to the agreement, for example, if the seller promised to fill up the land for you, you know, when they negotiate, sometimes they tell you all kind of things.
When you're the bargain, yes.
Kind of thing. You want those things to be included in the agreement, written included into the agreement.
Yes.
So they can't. It will be difficult for them to renege afterwards. Right?
Once it's written.
Yes.
Okay. We just have to take a very short break, and when we return, we will continue our discussion on know your rights when buying or selling land. We'll be right back. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney Lissette Staine, and we are discussing your rights when buying or selling land. So we got into a lot of the research that you need to do when you're trying to procure land. And you had mentioned that it would be good to either get an attorney or to go through an agent who is familiar with the system. But is it something you can do on your own?
It is, but I would recommend, okay, this is the thing. So in Belize, there's 5 different type of land title, freehold titles that a person can hold.
Okay.
Under the registered land system, it's easier to conduct land searches, because all you have to do is go to the land registry, fill out a form, and request a copy of the land register. And that register should contain all the details in regard to that land. So you would see everything on the register. When it's not under the registered land system, then it's a bit more difficult. It's a bit more tedious too.
Yes.
So, for example, where the title is conveyance, the person would have to look at the index. You pick up a book that's called the index, and the titles are indexed according to the name, the last name of the parties. So you look through the index, look at the reference, get the information from the reference, and you request the book, the deeds book. You pick up the deeds book, you look through the deeds book, and then you go to the folio that is reflected. You look at the, then you go to the document. When you reach the document, then you have to read the document and analyze what it's saying. So it's a bit tedious. If you don't know what you're looking for, you might miss certain things. And for those type of researches, I would recommend getting an independent researcher or hiring an attorney, because it's easy to miss. It's easy to miss if you don't know what you're looking for. And a lot of what we're discussing, and I just want a clarification, it is dealing with land being bought or transferred between a private citizen to another citizen. It's different from you buying land from like the government, or? It's different, yes. And I'm focusing on private transactions between two private individuals, as opposed to purchasing from government. I think that would be an entirely different, you need another show, another episode for that.
what about the payment methodology? What is the advisable way to pay for your land?
So after you sign up the contract, and like I said, you would want to put everything in there, all the terms in the contract.
Yes.
But of course, I always recommend using an escrow agent. So the escrow agent is a person or a firm where documents concerning the transaction would be placed or sent to, and the purchase price would be sent to the escrow agent. The attorney who has carriage of the transaction normally acts as the escrow agent. In Belize, a common practice is also for the real estate agent to act as the escrow agent. And some parties agree to have an international escrow agent act as their agent. So it protects both sides. So the agent normally would not release the purchase price until and unless he or she has all the documents required to effect transfer of title in his or her possession.
So this person just basically acts as a middleman in terms of the transfer, and so as the buyer, I would give to him the cash or so for whole to show that like I have the money or so. And then but it will not be released until terms or so are met.
Correct. And of course you could agree to different terms, but that's normally how it goes. You would deposit the money with the escrow agent, and the seller would deposit all the documents required, including the original land title and so forth, with the escrow agent, and it's released at closing, what we call closing, when everything is completed. No?
And all these things, as you said, and I think you have to emphasize, should be written in the agreement.
Yes, please.
You said yes, please, like you're encounter a lot of stress because of the agreement process. And what about deposits? When you have to make a deposit?
So the deposit, if there's an escrow in place, the deposit would also be made to the escrow agent. Yes, and the deposit is normally 10% of the purchase price.
10%?
Yes. The parties could agree to a different amount, but even if a party agree, let's say the buyer agrees to a non-refundable deposit of more than 10%, that buyer could challenge that clause if let's say the agreement doesn't go through and the seller retains the 40% or the 50%, whatever amount above 10% that was deposited. That same buyer could approach the court and successfully challenge a forfeiture. We call it a forfeiture clause.
Despite signing on to that agreement.
Despite signing on to that agreement, because what the court says that the amount must be reasonable, the amount to be forfeited, and it must be clearly stipulated in the agreement as well. And yes, it must be reasonable, and they have determined reasonable to mean about 10%. So anything more than that, especially in the case where the buyer isn't in possession of the property. So if they say, let's say they agreed to deposit, it's a $100,000 sale. They deposited $50,000, and they said by the end of the month I would have paid off the other $50,000. For some reason, they didn't manage to pay off the other $50,000, and the seller said, well, too bad, I got it the $50,000. They could challenge it as an unreasonable forfeiture.
And you mentioned that how if the seller keeps the deposit in the event of a forfeiture, but you can negotiate to get a return on your deposit in case in this sales agreement. That is something
That's the beauty of negotiation. You know, you could negotiate anything, and of course you don't want to negotiate in your favor. And seller and buyer have competing interests, and so I often tell clients both sides should try to get an attorney or get somebody to represent them. No?
As long as they get it in writing.
And in writing, yes.
We want to move into the issue of residents versus non-residents when you're selling land, because you first made a disclaimer that how we're speaking about from selling from private to private. Now, what's in the case of residents selling to a foreigner? What must be in place?
Okay, I think what you're getting at is the central bank permission, because that is one of the hot topics.
Yes, yes.
The legislation has been in place for years, but what has recently happened is that the Lands Department is now enforcing the exchange control regulations by requesting a copy of the permission letter from central bank, and that is required where non-resident is selling, transferring, gifting, mortgaging property to a non-resident. What did I say? A non-resident to a resident and a resident to a non-resident.
Yes, yes.
So once the transaction involves a resident and a non-resident, then you need to apply to central bank to get a permission to sell. But if it's between two residents or two non-residents, then that permission isn't required.
Two or even two non-residents, the permission is not
It's
required.
as between a resident and a non-resident. And
Okay, so just non-resident and a foreigner. And resident and non-resident, sorry. Actually, what I want to ask is for a clarification on resident.
Yes.
Because if I'm selling to a Belizean in
who lives
States,
in New York.
Yes, or so. Is that
that's a common question.
Yeah.
So central bank has issued a fact sheet describing what they deem to be a resident.
Okay.
So Belizean national who is living in Belize is regarding it as a resident. But if that person has been living outside of Belize for more than a year, then they regard that person as a non-resident.
1 year. Oh, wow.
Yes, for a year or more. Yeah, then that person is regarded as a non-resident.
Yeah.
A non-national who resides in Belize and with their resident status or with a work permit, and have been residing in Belize for a year, then that person is considered a resident.
Okay.
Yes. So that's a distinction that they use. Yes.
Okay. Thank you. We will take one more short break, and when we return, we'll continue our discussion on your rights when buying and selling land. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney Lissette Staine, and we are discussing your rights when buying or selling land. So, Lissette, I want to get into the issue of the stamp duty of the land and the valuation of the land. What is the process that happens, and how is the stamp duty really determined?
Okay. So, stamp duty is a valorum, meaning that it depends on the value of the land. So the first 20,000 is exempt from stamp duty.
Okay.
And the excess, if the land is being transferred to a Belizean citizen,
yes,
or a CARICOM national or a Belizean company, then it's 5% of the value of the land, or the amount of consideration. The consideration is basically the purchase price or the sales price.
Okay.
Right? But whichever is greater. So then if you have a purchase price in the transfer instrument of $100,000 and the Lands Department determines that the land is valued more than that, $150,000, then the stamp duty would be calculated on the value of the land, which would be the $150,000.
The higher one.
The higher amount, which is greater.
Yes.
The higher amount.
Yeah.
If you're not a Belizean citizen, then that percentage would be 8%, and that was recently changed this month, in fact, to 8%.
Okay. You said it would be charged on the $150,000. So is there a procedure that is used to determine that that is actually the value of the land for them to charge the stamp duty on?
You mean the procedure that Lands Department uses?
That they use, yes.
Okay. That procedure has been called into question.
Okay. You have a little frightened when I asked the question just now.
They would have to come and explain the procedure that they use, but it can be challenged. And in fact, the first step you can do is simply write a letter explaining why you don't agree with the valuation. If there's an official valuation that you have, you could submit that to them.
Yes.
And so you could challenge the amount that they say is the value. No?
And it sounds like something that is frequently challenged too.
Well, I don't know about frequently challenged, but there has been a lot of instances of the discrepancy between the consideration and what they deem to be the value of the property. Okay. Right?
Is there, a lot of people always rail up about the department taking long in transferring land. Is there a prescribed clause in the law, and I'm hoping that the answer is yes, that says this is the amount of time that they should take in transferring your land?
Then you'll be disappointed. And more disappointed to know that it often takes quite some time.
Okay.
The ones that I've done have taken about 3 to 5 months, transfers I'm talking about, to completion. But I've had some that have taken much longer than that. And I've known other persons who have submitted transfers that have taken over a year to completion and that are still pending. So there's no set time, and it's difficult to estimate how long they will take with it.
Lissette, this was some great information. What are the final thoughts that you would like to emphasize to Belizeans on the issue of buying and selling land?
Well, I will go back to one of the initial things we discussed, and that's putting everything in writing.
Okay.
Everything that you agreed upon, put it in writing. And don't feel pressured to sign contracts that you're not comfortable with. I've had a lot of people come and say that, well, they want to close, they want to finalize this contract within the next day, within the next 24 hours. They want the earnest money deposit to be in place within the next 24 hours. If you're not comfortable with it, don't sign it. Yes, it's purchasing land is a huge investment for most of us. So you have to take your time, understand what you're doing, get the assistance of people who know about how it works. No? So that would be my final words.
Well, thank you so much for coming and discussing this very touchy issue.
Thank you.
And sadly, we have come to the end of our show for tonight. Thank you, Lissette, for joining us and providing important information on tonight's topic. Next week will be our last show for the year, and you won't want to miss it. Just in time for Christmas shopping, we will be discussing Belize buy and sell with attorney Leroy Banner. Be sure to post your questions on our Facebook page. We also invite you to share our ideas and topics you would like us to cover next season. Tonight's episode of Know Your Rights repeats at 1 p.m. on Sunday on Channel 7, and it will also be available for your viewing on Facebook and YouTube. Thank you for watching, and good night.